This is an appeals court hearing that we heard today where we could hear in real time the arguments from the lawyers on both sides about gagging Donald Trump. Now, Jack Smith did win the first round in the D.C. coup case, but that gag order has not been in place. Indeed, it was held for this review today. The special counsel's team says Donald Trump has clearly shown in his violent rhetoric and his calls for violence and his calls for other things that sound like basically witness intimidation means he has to be gagged. Now, Trump's lawyers say the gag order, first of all, is overly broad, but second of all, they think the whole thing in its entirety is basically a violation of the First Amendment and the free speech rights afforded to everyone, including especially a presidential candidate who's engaged in political speech, which, of course, can include legitimate criticism of the current administration, which oversees the Justice Department. Now, special counsel Jack Smith was in court today, and despite the judges pushing back at prosecutors at times, we could tell you one headline from the New York Times is this. They write that based on the arguments which we heard today, there's been no ruling yet, of course, but based on the tenor and the substance of what the judges said in their questioning, it looks like the court is poised to hand Jack Smith a win, keeping the gag order, although the judge is signaling they may narrow it. Now, like I mentioned, we have obviously had other court hearings in this case, including at the lower court level, after Jack Smith indicted Donald Trump as a defendant. Indeed, if you think back a ways, I attended one and told you guys about it. Glenn Kirshner and I spoke about it at the federal courthouse. One difference that goes to how we learn things was those district court hearings, lower level, don't give us live audio. Now, you may be thinking, what about Supreme Court and other times where it seems like the day of we get a lot of audio? Well, in the appeals court process, depending on the hearing, you can sometimes get same day audio, which is very interesting because it takes us inside the room. If you've ever had a text message that doesn't always give you the full flavor of somebody saying the same thing, well, this is kind of like the court version of that. And so we have some great guests standing by, but first I want to share with you some of these new highlights, audio from today's arguments.
The order is unprecedented, and it sets a terrible precedent for future restrictions on core political speech.
He's a high-profile public figure who posts lots and lots and lots of followers. He's expressing his views as the First Amendment allows.
Is the sheer number of occurrences?
It's not the role of the government to dictate what topics are appropriate or necessary to discuss in the context of a political campaign.
When the defendant engaged in repeated inflammatory personal attacks on someone, there's a causal link between that person then receiving harassment, threats, and intimidation.
That last statement from one of Jack Smith's top appeals litigators here, and you know when you're dealing with something as unprecedented as the federal criminal trial of a former president, you're going to have appeals. So Jack Smith has proven to be pretty organized. We've looked at that. This is one of the people he picked to deal with exactly this situation, where something that would be really automatic in any other case. If you are accused of crimes against the United States government linked to a violent insurrection, and you blatantly, publicly impugn people, attack witnesses, attack court officials, and do other things referring to violence, yeah, you're going to get a gag order. Now, there are differences, of course, that are legitimate, which is to say, not just holding back because someone's a politician. That's not how it's supposed to work. But the public interest issues that are raised by someone who is running a campaign can be different. And the First Amendment does, as lawyers say, care about that. And these arguments we know were of interest to the judges. We cannot predict how they're going to rule. I told you the New York Times interpretation, but we know the judges were interested because they allot a certain amount of time. It's usually kept, but they can go over if they want. They are the judges in charge. And this argument today went longer than the schedule. The judges grilling both sides for over 2 hours.
Would your position be any different if it were a year ago?
Certainly a year ago, we would still be in the midst of a political campaign. I believe President Trump...
When are we not in a political campaign? Would your position be any different a year ago?
I think the gag order would still be unconstitutional.
Would your position be any different?
I don't see how it would be
different. So the fact that we have a campaign going on does not matter.
The judge there doing what appeals court judges do sometimes, which is push the person to concede or deal with something on the record. And the point isn't that Donald Trump has no First Amendment rights, but rather that some of the rhetoric from his lawyers saying, well, we're in a campaign right now, and that's something we know the client, Donald Trump, cares a lot about because he timed his campaign to start earlier thinking it might help him somehow. Well, the judge is basically saying, well, if your position is the same no matter what, and it's a constant campaign, or it's always been that you want the gag order to say it's unconstitutional, that doesn't really matter that we're in a campaign. Now, again, that's an interesting exchange that we wanted to highlight for you. We don't know whether that means these judges will come down to completely side with Jack Smith and gag Donald Trump thoroughly and fully, or something in the middle, or overturn the whole thing. The New York Times reporting, as I mentioned, by the end, the judges signaled they would likely narrow the scope of people covered by the gag order, including potentially freeing Mr. Trump to attack Prosecutor Jack Smith himself, who was, as mentioned, sitting in that high-profile court hearing today. Now, we have more excerpts coming up because we're kind of going to go through this together and make it all make sense. But I want to bring in our special guest, Maya Wiley, former SDNY civil attorney, and David Kelly, former SDNY criminal chief. So he ran all the prosecutions there. And I should mention my former boss. Welcome to both of you. David, from the quotes I just showed, as well as any other of the hearing that you gathered, where do you see this headed?
Well, first, let me say this was a fun argument for a lawyer to listen to because the bench was really hot, meaning that they just didn't pick up these briefs 5 minutes before getting on the bench. They really focused on this. I think at the end of the day, the bottom line is they're probably going to tinker with this ruling, with Judge Chutkan's gag order, and they're going to keep it in place, but they're going to tinker with it a little bit. I think what we're seeing here is a collision between the First Amendment protection of political free speech and the sanctity of criminal proceedings. What kind of bugged me about the whole thing, and I don't think this is something that's really going to resonate with the judges, is that, you know, in lots of criminal cases, judges look at what defendants have chosen to do. It's their choice to do, and at the end of the day, the criminal proceeding takes precedent, and they have to make some sacrifices in their own life. And in this case, former President Trump has chosen to enter a campaign, despite the fact that he knew when he entered the campaign that if criminal charges were imminent, and that he would have to make some sacrifices. And I think that the sanctity of the criminal justice proceedings here are going to probably win out a little bit here, where, you know, the low-hanging fruit, Jack Smith, the judge, and so forth, he's going to be able to criticize. But to go beyond that, to make any sort of statements or actually retweeting, as he did earlier today, kind of threatening communications to the general public, I think will be prohibited. And I think ultimately it should go up to the Supreme Court, will be upheld.
Interesting. And I'm going to play some more and bring in Maya. But just on that point, David, you're basically reminding us or showing us how this isn't a black and white, one-size-fits-all thing, and that going after what might be called the court process and the regular civilians who are called into this, who are called in to do their civic duty, might, by the judges, ultimately be looked as much more off limits than, say, criticizing Jack Smith, who is a big boy and part of the government. And sometimes to make your case both in and out of court, you may criticize that.
I think that's right. And look, I think witnesses are going to be protected. I think jurors are going to be protected. I mean, the type of information that may unfairly influence a jury is going to be off limits. But I think there's going to be a lot that he's going to be able to say, critical of the process, critical of the administration. It's a political persecution, all the things that legitimately he should be able to say in advancing his campaign is going to be fine. But those things, when he kind of targets, and this is a tough question, targets, when he starts focusing on kind of the things that are only particular to this prosecution, witnesses, facts, and things like that, I think will legitimately be off limits because it really doesn't go. I mean, they use this, this notion, core political speech, which is what Trump's lawyers tried to hide behind. I don't think is going to fly. Yeah. I also don't think, one of the things, the big weakness I saw in Trump's lawyers' argument was every kind of hypothetical that was posed to him. And you're right, appeals court judges do this. And that's one of the fun things about making appellate arguments. You have to really think on your feet. And in almost every instance, his response, well, it depends on the context. And if I'm a judge, I'm thinking, okay, I'm giving you all the context, and that's it. And he kept on pushing, but you need context. Well, guess what? You have to have prophylactic measures here because we're talking about the sanctity of criminal justice proceeding, and we're talking about potentially the safety of witnesses.
Yeah, and I don't want to and I want to echo that, David, and bring in Maya. I don't want to overemphasize the point, Maya, but if you're trying to have the refs call a game and somebody's standing on the sidelines, either holding a gun or encouraging 100 other people to come down and do the violence for them. Maybe they're not the type of person who does it themselves. Maybe they're the type of person, say, hypothetically, Maya, who likes other people to take the risk and do the dirty work. Yes, it's going to affect human beings when the specter of violence is in the air. I say that to bring it out to you, Maya, and play one more brief part here where they brought up, and again, I'm not exaggerating, Donald Trump did call or muse about the murder, the assassination of a United States general. Take a listen to this part.
So what's not fair game? So he can comment.
Yes.
And he can comment very critically. What can he not do?
Use the sort of inflammatory language that poses a significant risk that they will be subject to threats, harassment, and intimidation. If the defendant were to say, not with any reference to their testimony, but say this person, is a coward, a liar, and a treason, and deserves a punishment of death, without any reference to what the substance of their testimony would be, I think that would still violate the order.
Maya?
Well, yeah, I think this goes straight to what is so complicated and interesting about this process, as David said. And I do agree with David that I think there is still going to be some form of gag order here. And the question is on what? But this is why, like our constitutional order and the First Amendment is based on this notion that we want a free expression of ideas. And particularly for political speech, that's the speech we protect the most. And we particularly care about it not restraining it before someone's able to make it. And, that's what we call the prior restraint. And you can see the judges kind of testing this out. What is the limit? Like, when is a political candidate able to talk about someone because they're a candidate for office? And this is a person arguably attacking them, at least in the form of making statements out in public. So what can Donald Trump do? And this interchange is actually a really interesting example of what's the boundary in an unprecedented situation.